Are you ready to go?
Yes, sir. Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on the mismanagement of the Civil Rights Division of the Department of Justice. Our second witness today is Mr. Harry Mihet, Senior Litigation Counsel with Liberty Counsel, an international nonprofit litigation, education, and policy organization dedicated to advancing religious freedom, the sanctity of life, and the family. Liberty Counsel is associated with Liberty University, which I am proud to say is in Lynchburg, Virginia, a part of the 6th District that I represent. Mr. Mihet grew up in communist Romania, where his father pastored 17 mostly underground churches. Because of this, his family suffered great persecution. At the age of 12, he participated in the Christmas Revolution of 1989, which overthrew Romania's oppressive communist regime. Once he immigrated to the United States, Mr. Mihet received his undergraduate degrees in political science and criminology from the University of Florida and graduated magna cum laude from Duke University School of Law. Mr. Mihet, welcome.
Chairman Goodlatte, Ranking Member Conyers, and members of the Judiciary Committee, thank you for inviting me to testify before you today. My name is Horatio Mihet, and I'm Senior Litigation Counsel at Liberty Counsel, a nationwide nonprofit firm dedicated to protecting our first freedoms. Having grown up under a totalitarian regime, I have seen firsthand what happens when the very government agency charged with protecting civil rights becomes complicit in violating them. Unfortunately, that is precisely what the Civil Rights Division, under the leadership of Thomas Perez, has done with Liberty Counsel's client, Susan Pine, a 61-year-old American from Florida. Susan has, for over 20 years, spent her free time outside of an abortion clinic, peacefully counseling expectant mothers about alternatives to abortion. In 2009, after trying unsuccessfully for years to silence Susan, the abortion clinic began to entreat the DOJ to eject her from that public square. Mr. Perez readily agreed, and he assigned 7 of his top litigators, including himself, to file a lawsuit against Susan under the Freedom of Access to Clinic Entrances Act, or FACE. Now, before filing this lawsuit, Mr. Perez flew several of these taxpayer-funded lawyers from Washington, D.C. to Florida in November 2009 to have a taxpayer-funded stakeout outside this clinic to see if by chance Susan might violate the law while these lawyers are hiding in the bushes watching her. In its lawsuit filed 9 months later, the DOJ then claimed that on the same day that its lawyers were descending upon West Palm Beach, Susan obstructed one vehicle attempting to enter the clinic's parking lot. Now, there were many clear signs indicating to every reasonable observer that this was nothing more than a political prosecution not grounded in any fact or law. First, there was no victim. No one actually came forward to complain of being obstructed. Instead, the lawsuit was filed entirely based on what one police officer claimed that he saw from the bushes 300 feet away. This officer conveniently forgot to record the license plate of this phantom vehicle, and he forgot to identify this mystery driver that was allegedly obstructed, so that all we had was his word. Second, Mr. Perez didn't file his lawsuit in November 2009. He waited over 9 months to file it, just long enough for the clinic to conveniently destroy the videotapes from its surveillance cameras as well as its patient sign-in sheets. The court found that the DOJ was, quote, negligent and, quote, even grossly negligent in its failure to preserve this critical evidence. Third, the DOJ claimed that Susan, quote, stopped and stood in front of a vehicle in the pedestrian crosswalk. Now, this allegation was entirely made up by the DOJ because its own witness, the police officer hiding in the bushes, testified under oath that once this phantom vehicle stopped, Susan, quote, immediately got out of its path, end quote. The officer himself admitted that she did not stop and stand in front of any vehicle. And so, after almost 2 years of litigation against Mr. Perez and his legal dream team, the court concluded that the DOJ suit did not even warrant a trial and granted us summary judgment. Judge Reiskamp said, quote, the court is at a loss as to why the government chose to prosecute this particular case in the first place, end quote. He concluded that the DOJ's position was inconceivable and absurd, and he suspected a conspiracy was afoot between the DOJ and the clinic to deprive Susan of her First Amendment rights. We asked the court, based on its findings, to sanction Mr. Perez and his legal team for filing a frivolous lawsuit. Rather than await the results of that motion, Mr. Perez and his team quietly paid $120,000 out of the public treasury and then moved on to their next target. So throughout this litigation, and several others like it, the leadership at the Civil Rights Division has demonstrated that it cannot be trusted to follow the law whenever it conflicts with their ideology. We therefore would urge this committee to exercise its constitutional authority and oversight, and to take whatever steps are necessary to restore the public's trust in the institution that is charged with safeguarding and protecting our most basic and cherished freedoms. I thank you for inviting me, and I look forward to answering any questions that you might have.
Thank you very much.
Mr. Mihet, in your written testimony, you provided an email dated November 5th of 2009. And incidentally, your story, sir, compels all of us greatly. But this was a Civil Rights Division attorney that wrote the email to an employee of the Presidential Women's Center, which in part states, quote, on Saturday, we'd planned to observe the protesters. Usually we just hang outside the clinic and observe, as well as chat with the escorts. We'd planned to leave on Saturday afternoon, unquote. Now, can you elaborate, again, put some context in this situation, elaborate on the Civil Rights Division's presence in West Palm Beach, and do you think that the proponents of abortion who claim that you got lucky in this case with a judge who is himself an ideologue, of course, and that the outcome would have been different in any other court? Can you put that in context and help us understand that?
Yes, the written documentation we obtained in discovery revealed a very sinister plan that began way before the lawsuit was actually filed against Susan, in which the Department of Justice planned an elaborate trap against Susan and others of her pro-life friends. The emails showed that they were on a first-name basis with the clinic staff, Mona and Julie, and they were making all these plans, and multiple DOJ lawyers were flying from Washington, D.C. to Florida. Now, perhaps the weather differential in February might account for some of that eagerness to travel to Florida on the taxpayer dollars. But that fact was easily lost upon Susan, who all of a sudden is being prosecuted by the most powerful government on earth. As to your second question, if you read Judge Reiskamp's opinion, which has been provided in the written submission, it is well-reasoned and supported by the law. He exercised remarkable restraint in the face of what he clearly understood to be frivolous and outrageous conduct. Any other judge faithful to the Constitution would have reached the same result. How do we know that? The DOJ could have appealed that decision if they disagreed with it. In fact, Professor Begenstas was an attorney at the DOJ at the time, perhaps the only attorney who managed not to have his name on the pleadings in this particular case. But he was in charge of the appellate division. If they thought the judge was off base, they could have appealed the decision. They chose not to. They quietly paid the significant attorney fee sanctions out of the public treasury and then moved on to their next target.
Thank you, folks, and thank you, Mr. Chairman.
Mr. Mihet, you spoke about the case you all were involved in, and you said that it was government actors, they lost evidence, they didn't have the license plate, the police officer was the only witness. As a defense attorney, I want you to know that that's not that far from the norm of many cases that I see. Is this the only case that you all have ever initiated that there was only a police witness and not much further evidence?
This was the only case where the one eyewitness put forth by the plaintiff, the DOJ in this case, came back and actually refuted the very claim that the DOJ was making. Here they said that Susan, quote, stopped and stood in front of a vehicle. This one and only eyewitness comes and testifies that, no, she immediately moved out of its way.
In all of your practice of law, is this the first time that you've seen that happen?
In all of my practice of law, I have never seen the kind of politically motivated conduct that I have seen in this case from any plaintiff, let alone a government.
We were just talking about a witness contradicting the reporter themselves.
Right. Well, what's interesting here is that both the police officer and the DOJ.
Is it the first time you've seen a witness contradict the prosecution in all of your practice of law? It's very simple.
It's my first time that I've seen it to this extent. After no one disputed that this police officer and the DOJ had conferred before the lawsuit was filed. We have the documents going back and forth between them. There was no reason for them to misunderstand each other. What I submit to you happened.
I take you at your word. In your vast experience, is the first time you've seen a witness contradict the prosecution. I yield back.
To this extent.
On behalf of Chairman Goodlatte and all the members of the Judiciary Committee, I want to thank all of our witnesses for your patience and your comedy towards one another with a T and with the full committee. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. With that, thank you again on behalf of all of us, and this hearing is adjourned.